There are people who have held a small amount of power for just long enough to forget that it was ever small. I've followed legal proceedings for a long time. Cases that make the news, cases that don't, cases that exist in the quiet middle space between those two things, where the stakes are entirely real for the people inside them, even if no one outside is watching. And every so often, a case arrives that is almost perfectly constructed to illustrate something about human nature, about what happens when authority is confused with identity, when a person mistakes the position they occupy for the person they are. This is one of those cases. The man at the center of it was named Dale Pruitt. He was 63 years old. He had been the president of the Fairview Meadows Homeowners Association for 11 consecutive years. 11 years of running the meetings, signing the letters, approving the landscaping standards, enforcing the parking regulations, and generally conducting himself as the unelected sovereign of a residential community of 212 homes in a suburb that, by any reasonable measure, no one outside of it had ever thought much about. He drove a late-model SUV that he parked always in a spot just slightly too close to the fire lane. He wore a polo shirt to every HOA meeting with his name embroidered on the breast pocket. He had a placard in his garage that said, in brass lettering, President, not HOA President, not his name, just President. That detail matters more than it seems. By the time this story reaches a courtroom, and it does reach a courtroom, in a way that Dale Pruitt did not anticipate and will not soon forget, he had spent over a decade constructing a version of himself that required constant external confirmation. The polo shirt, the placard, the 11-year tenure, the particular way he walked into meetings 3 minutes late so that everyone was already seated when he arrived. He had built a small empire and mistaken it for a large one. The problem, as it usually is with people like Dale, was not the power itself. Small community governance serves a real function. Rules about maintenance standards and noise levels and common area usage exist because neighbors need frameworks for coexistence. The problem was what he had done with the role once he was comfortable in it. Which brings us to the Reyes family. Victor and Anna Reyes had lived in Fairview Meadows for 6 years. Victor worked in heating and air conditioning, long days, physical work, the kind of job that builds calluses and a quiet sense of pride in competence. Anna managed the books for a small dental practice. They had 2 children, a son of 14 and a daughter of 9. Their home was maintained. Their lawn was kept. Their neighbors liked them. What they also had, on the side of their house facing the driveway, was a small ramp. Anna's mother, Lucia, had moved in with them approximately 20 months before this story becomes about. She was 78 years old and used a wheelchair following a stroke that had left her with limited mobility on her left side. The ramp was not large. It was not decorative. It had been installed by a licensed contractor, built to code, designed to allow Lucia to move between the house and the vehicle that transported her to medical appointments, to physical therapy, to the small weekly occasions that made her life manageable. It was, by any reasonable human standard, entirely unremarkable. A family caring for an elderly relative, a practical accommodation, the kind of thing that most people, encountering it, would not think about for more than a moment. Dale Pruitt thought about it quite a bit. The first notice arrived 6 weeks after the ramp was installed. It cited the Fairview Meadows Architectural Guidelines, which required HOA approval for any modification to the exterior of a property that altered its visible profile. The ramp, the notice stated, had not received prior approval. The Reyes family was given 30 days to submit a retroactive application for review or remove the structure. Victor submitted the application. He included photographs, contractor documentation, and a brief explanation of Lucia's medical situation. He was not a man who was accustomed to writing formal letters, and the explanation was simple and direct. His mother-in-law had had a stroke. She used a wheelchair. The ramp was how she got in and out of the house. The Architectural Review Committee, which consisted of Dale Pruitt and two neighbors who, it would later emerge, had never once voted against Dale Pruitt's recommendation in 11 years, denied the application. The denial letter cited concerns about the ramp's visual consistency with the neighborhood's established aesthetic. It offered an alternative. The Reyes family could pursue an interior solution that did not alter the exterior profile of the home. Victor read the letter twice. Then he called Anna into the kitchen and read it to her. Then they both sat quietly for a moment, in the way people do when something has happened that they're still deciding how to process. An interior solution. For a woman who needed to get from the house to a vehicle. They appealed. Dale Pruitt's committee denied the appeal. A second notice arrived, now citing an accumulating daily fine for non-compliance. $25 per day. It had been running, the notice explained, since the original 30-day window had closed. That was the moment Victor Reyes decided to contact a lawyer. Her name was Margaret Allison. She had been practicing fair housing and disability accommodation law for 16 years. She was a small woman with reading glasses she wore on a chain, and the particular patience of someone who has heard many versions of the same story and has stopped being surprised by any of them. She listened to Victor describe the situation. She asked a few specific questions. She requested copies of all the correspondence. Then she told him something that shifted the entire axis of the situation. She told him that the Fair Housing Act, along with its subsequent amendments, specifically requires housing providers, including homeowners associations, to make reasonable accommodations for residents with disabilities, or to permit reasonable modifications to the property at the resident's expense, when those modifications are necessary to afford the person with a disability equal opportunity to use and enjoy the home. The ramp, she explained, was not a request. It was not subject to an aesthetic review committee's approval. It was a legally protected modification, and the HOA's attempt to fine the Reyes family for installing it and to demand its removal was not a matter of community governance. It was a potential violation of federal law. She filed a complaint with the Department of Housing and Urban Development and simultaneously filed a civil suit against the Fairview Meadows HOA. Dale Pruitt's response to being served was, according to sources familiar with the situation, not one of reflection. He called an emergency HOA board meeting. He described the lawsuit as harassment. He told the assembled homeowners, a meeting he had called on 4 days' notice on a Wednesday evening, that the Reyes family was attempting to use a loophole to avoid following the rules that everyone else in the community followed. He used the phrase, "everyone else follows the rules," 4 times in approximately 20 minutes. He also suggested, in terms that were not quite explicit enough to be immediately actionable, but were clear enough to be understood, that Victor Reyes's decision to sue was the kind of thing that certain types of people did when they didn't want to participate in a community properly. 2 homeowners walked out of that meeting. One of them, a retired teacher named Barbara Hollins, wrote down what Dale had said and dated it. She would later provide that documentation to Margaret Allison. The case was assigned to Judge Leonard Ferris. He had been on the bench for 22 years. He was not a dramatic man. He had the quality of someone who had seen enough human behavior that very little of it surprised him anymore, and who had developed over time a preference for directness that some attorneys described, cautiously, as intensity. He ran his courtroom with a calm that was, for people who understood it, more authoritative than any amount of volume. He had also, early in his career, before law school, worked with a nonprofit that provided housing assistance to elderly and disabled residents. This was not a secret. It was in his publicly available biography. But it suggested something about how he understood the practical weight of the legal principles his courtroom was now being asked to apply. The preliminary hearing was held on a Tuesday morning. Margaret Allison appeared on behalf of the Reyes family. The HOA was represented by a lawyer named Curtis Webb, a defense attorney who had worked with HOA boards before and who specialized professionally and temperamentally in finding procedural ground to stand on. Dale Pruitt attended the hearing. He was not required to, but he came, dressed in a blazer over a collared shirt, and sat in the gallery as though the courtroom were an extension of one of his HOA meetings. He arrived notably 3 minutes after the scheduled start time. Judge Ferris was already on the bench. The early portion of the hearing was procedural. Margaret established the timeline, the installation of the ramp, the application, the denial, the fines, the appeal and second denial, the legal basis for the accommodation claim under the Fair Housing Act. Curtis Webb contested several points, argued that the HOA had followed its own procedures, and suggested that the Reyes family had options they had not fully explored before resorting to litigation. Judge Ferris asked a question that was directed at Curtis Webb, but which carried its weight toward the gallery as much as anywhere else. He said, "Counselor, what interior solution would allow a 78-year-old wheelchair user to independently access the exterior of her home for medical transport?" Curtis Webb began an answer that involved alternative ramp configurations and interior threshold modifications. Judge Ferris listened to approximately 45 seconds of it, and then said, without raising his voice, "I'm asking what solution exists, not what solutions were proposed. What specifically would have achieved the same result as the exterior ramp without an exterior ramp?" There was a pause. Curtis Webb said the committee had believed alternative solutions were available. Judge Ferris said, "What solutions?" Curtis Webb said the denial letter had outlined that the applicant should explore further options. Judge Ferris looked at the denial letter, which was in evidence. He looked at it for a moment. He said, "The denial letter does not identify any specific alternative. It states that interior solutions should be pursued. Is that accurate?" Curtis Webb confirmed it was accurate. Judge Ferris made a note. From the gallery, something happened that courtrooms are not designed to accommodate. Dale Pruitt leaned forward and said, at a volume not intended for the bench but audible to it, "That's not how you run a meeting." The courtroom went quiet. Judge Ferris looked up from his notes. He looked at the gallery. He looked at Dale Pruitt. He did not say anything immediately. He simply looked, with the patience of a man who has learned that silence, applied correctly, carries more weight than almost anything else. Then he said, "Sir, I'm going to ask you to identify yourself for the record." Dale stood. He said his name. He said he was the president of the Fairview Meadows Homeowners Association and a named party in the proceedings. Judge Ferris said, "Mr. Pruitt, you are in my courtroom. You are welcome to observe these proceedings in silence. You are not welcome to speak from the gallery. Is that clear?" Dale said, "I just think there are some things that need to be said that aren't being represented." Judge Ferris said, "Mr. Pruitt." One word. The tone of it was not loud. It was not theatrical. It had the quality of a door closing. Dale sat down. Curtis Webb looked at his notes and appeared to be finding them very interesting. The hearing continued. Margaret Allison walked through the timeline with the kind of methodical clarity that had clearly been built over many careful hours of preparation. She introduced the fines documentation. At the time of the hearing, the accumulated daily fines had reached $4,375. She introduced the HOA's governing documents. She introduced the specific provisions of the Fair Housing Act and accompanying HUD guidance on reasonable modifications. She also introduced Barbara Hollins's written account of Dale Pruitt's comments at the emergency HOA meeting, the account that included the phrase, "certain types of people." Curtis Webb objected to its relevance. Judge Ferris overruled the objection and read the document in its entirety before setting it down. He asked Margaret whether there were any other witnesses or documentation she intended to present. She said she had one additional item. She introduced a letter signed by 11 of the Reyes family's neighbors in Fairview Meadows, expressing support for the accommodation and stating that the ramp had not affected their enjoyment of the neighborhood or their property values in any way. Several of the signatories had been Fairview Meadows residents for more than a decade. 11 people. In a community where, for 11 years, Dale Pruitt had operated with the assumption that he spoke for everyone. From the gallery, there was a sound, not words, but the kind of audible breath that people release when they're working to contain something. Judge Ferris did not look up. He continued reading the letter. When he was done, he set it down and addressed both attorneys. He said that based on the documentation before him, the HOA's denial of the accommodation request appeared to be in direct conflict with the requirements of the Fair Housing Act, and that the continued imposition of daily fines for a modification that was federally protected raised serious concerns that would need to be addressed before the full trial. He ordered an immediate freeze on the accumulation of additional fines pending the outcome of the case. He also ordered the HOA to provide, within 30 days, a written legal basis for their determination that the ramp did not qualify as a reasonable modification under federal law. Not a reference to their own architectural guidelines, but a specific legal argument grounded in the Fair Housing Act itself. And then he looked at Dale Pruitt in the gallery. He said, "Mr. Pruitt, I want to address something directly." Dale, to his credit, if credit applies, was still. Judge Ferris said, "The role of an HOA board president carries genuine responsibilities to the community you serve. Those responsibilities include knowing when the authority you exercise is bounded by laws that exist independently of your governing documents. Federal disability accommodation law is one of those laws. It is not a loophole. It is not a technicality. It is a protection extended to people who need it, and it takes precedence over neighborhood aesthetic guidelines. I would encourage you to speak with your legal counsel at length before this case proceeds further." Dale said nothing. Judge Ferris said, "I mean that as serious guidance, not a formality." The hearing ended. People began gathering their things. Margaret Allison closed her folder. Curtis Webb had a brief, quiet conversation with his client that those nearby described as one-sided in a direction that was not comfortable for Dale. Victor Reyes sat in the courtroom for a moment after the room began to clear. Anna had been beside him the entire hearing, her hand in his, and she didn't move until he did. When he finally stood, he looked at the bench, at the empty bench now, because Judge Ferris had already left, and he exhaled in the way that people do when they have been holding something for a long time. Lucia had stayed home. She didn't know the details of what was happening in the courtroom, only that her daughter and son-in-law had gone somewhere important. When Victor and Anna came home, she was in the living room, watching a program she liked. She looked up when they came in. Anna sat next to her and told her, in Spanish, that things had gone well today. Lucia patted her hand. In the weeks following the hearing, several things happened. The HOA's legal team, after reviewing the federal statute and the HUD guidance that Margaret had submitted, informed Curtis Webb that constructing the legal argument the judge had requested was not going to be straightforward. The Fair Housing Act provisions on reasonable modifications were not ambiguous. They were clear, consistently interpreted, and well established in case law. The argument the HOA would need to make was not a strong one. Curtis Webb had a frank conversation with the HOA board. 3 board members, following that conversation, voted to pursue settlement. Dale Pruitt voted against it. The vote was 3-2. Dale did not take the outcome well. He called one of the board members who had voted for settlement, and, in a phone call that the board member later characterized as not appropriate, expressed his feelings about the decision at length. The settlement included a formal withdrawal of all fines related to the ramp installation. The $4,375 in accumulated charges was dismissed entirely. The HOA formally recognized the ramp as a protected modification under the Fair Housing Act and agreed not to pursue further action against it. The settlement also included a provision requiring the HOA board to complete a training session on fair housing obligations, a requirement that applied to all board members, including the president. The training was conducted by an outside organization. Dale Pruitt attended. He sat in the back row. He did not ask questions. The ramp stayed. Lucia used it the following Thursday to get to her physical therapy appointment, the same way she had used it every Thursday since Victor had it installed. The drive took 20 minutes. Her therapist said she was making progress with her left side mobility, slowly but measurably. Small improvements, the kind that matter to the person experiencing them, even when they're invisible from the outside. Dale Pruitt retained his position as HOA President for a further 4 months, at which point the annual election came around, and, for the first time in 11 years, a candidate ran against him. The candidate was Barbara Hollins, the retired teacher who had walked out of the emergency meeting and written down what Dale had said. She won by a margin that was not close. Dale attended the first meeting of the new board. He sat in the front row, in the seat he had occupied as president for 11 years, and watched someone else run the meeting. He didn't say anything. He left before it ended. No one is certain whether he has attended a meeting since. Here's what I want to stay with for a moment, because this case is worth thinking about beyond its specific facts. Dale Pruitt was not an unusual person. That's the part that matters. He was not a uniquely corrupt official or a rare example of something extreme. He was an ordinary man who had been given a small authority and had, over a long time, allowed that authority to become the primary thing he understood about himself. The embroidered polo shirt, the brass placard, the 11 years, the 3-minute late arrivals so that everyone would be seated when he walked in. All of it was the infrastructure of a self that needed constant reinforcement. And when something arrived that the infrastructure couldn't process, a federal law that didn't care about aesthetic guidelines, a family that retained a lawyer instead of quietly complying, a judge who asked what, specifically, the alternative would have been, the infrastructure cracked. Because authority that is only legitimate within a small, closed system is fragile in proportion to how closed the system is. The moment it touches something larger than itself, the proportions become visible. That's what Judge Ferris represented in this story. Not a dramatic intervention, not a rescue. Something simpler and more durable, a larger system, calmly doing its job. Asking the questions that the small system had never had to answer, requiring specificity where vagueness had been sufficient, naming the law that existed outside the governing documents. He didn't raise his voice once. He didn't have to. The calm was the point. When you have the actual authority, you don't need to perform it. Dale Pruitt, by contrast, had spent 11 years performing it. The performance had worked, within Fairview Meadows, because the audience was contained. The moment the audience changed, the moment a federal courtroom replaced a Wednesday night HOA meeting, the performance had nothing to sustain it. And the gallery comment, "That's not how you run a meeting." That moment is the clearest distillation of everything this case is about. A man so accustomed to being the authority in the room that he could not adjust, even briefly, to being the audience. Even in a setting where the consequences of speaking out of turn were real and immediate. Even with a judge on the bench who had 22 years of experience with people who forgot where they were, he couldn't help it. He had forgotten, or perhaps had never fully understood, that his authority had always been conditional, that it existed because the community granted it, and because the law permitted it within certain limits, and that the moment those limits arrived in the form of a federal protection for a 78-year-old woman in a wheelchair, his authority didn't just stop being useful, it stopped being real. The ramp is still there. It's a functional object, wood and hardware and a gentle slope, painted to match the trim of the house. Most people driving past it would not look at it twice. It doesn't announce itself. It just does what it's there to do. Lucia uses it every Thursday. That's the resolution. Not the settlement amount, not the election result, not whatever Dale Pruitt is doing now. The resolution is a 78-year-old woman using a ramp to get to her physical therapy appointment on Thursday mornings, which she was doing before this entire story began, and which she is doing still. The legal case changed things for the family in material ways. The fines removed, the protection formalized, the precedent established within that community. But the thing that mattered to Lucia was already there. Her daughter and son-in-law had built it for her. They had kept it through everything that followed, and the law had confirmed, through an extended and exhausting process, what should have been clear from the beginning: that a family caring for an elderly relative deserved to do so without being fined $25 a day for installing a ramp. That's not a complex principle. It's not a nuanced legal argument. It's a statement about what communities are for, not for the enforcement of visual consistency, not for the preservation of one man's authority, not for the careful policing of architectural profiles. They're for the people who live in them, all of them, including the ones who need a ramp. The case ended, the meetings continued, now with a different president who, by all accounts, runs them on time and listens when people speak and has never once had a brass placard made with her title on it. The physical therapy continues, and somewhere in Fairview Meadows, there is a garage with a brass placard that says President, and the word it carries now means something different than it did before. Not the weight of 11 unquestioned years, but the quiet reminder that authority is not the same as entitlement, and that the law, when you need it to, knows the difference.